And please welcome Chris Witteman from the California Public Utilities Commission, who's going to talk a bit about we'll get Chris's slides up, regulators read on the open internet order and regulatory proceedings. So here's your clicker.
Where do I push? Bingo.
Okay, forward, back.
Thank you. Good morning. It's a pleasure to be here. My name is Chris Witteman. I'm Senior Counsel at the California Public Utilities Commission. I'd really like to thank you for having me here, and especially thank Tony for his patience in fielding my questions over the weekend. First, a disclaimer. I am not here representing the California Public Utilities Commission. I'm speaking on my own behalf, and my views are my own and should not be attributed to the Public Utilities Commission. The second caveat is the open internet order itself. This is a 400-page tome. It has multiple parts, over 2,000 footnotes, not all of which are consistent, internally consistent. So I can't pretend to have mastered it all, and may have to get back to you on some of your questions. So with that said, I'm honored to be speaking from the same stage, figuratively, from which Christopher Yu addressed you at your winter meeting. I have a very different perspective than Professor Yu, but I do agree with two things that he said at the outset of his speech. One, lawyers and policymakers need to understand the technology a lot better, and technologists may need to understand aspects of the policymaking world better. So I'm looking forward to dialogue, to your questions. This is why I'm here, and hopefully we can close that gap. The second thing he said was the U.S. has adopted a different regime than the rest of the world when it comes to internet access. For the rest of the world, broadband internet access service is part of an existing regulatory regime that governs all electronic communication networks, cable, fiber, copper, wireless, and transport, and all protocols, whether they be TDM, IP, or other. In the United States, we've tried to develop separate rules specifically tailored to internet access and IP network, built on the notion that access to the internet is itself an information service, one that you can't separate from its transport underpinnings. So that really is the theme of what I'm going to be talking about today. So blow through that. Common carriage is a concept that goes back into the common law, 16th, 17th century, bridges, ferry boats, bottleneck facilities, and its key components were non-discrimination rule and fair and reasonable rates. In our context today, and in the context of the open internet order, the fair and reasonable rates this is not about rate setting. So we're going to focus on the non-discrimination portion of common carriage. The primary analog in the United States is the railroad. In response to widespread public outrage about the power of the railroads, the power of the railroad barons, and how they could control the United States and California economy and the politics. It's one reason, by the way, why the Public Utilities Commission is in San Francisco and not in Sacramento. In response to that, on the federal level, you had the Interstate Commerce Act of 1887 and the founding of the California Public Utilities Commission, which was then called the Railroad Commission. Common carriage is also the foundation of telecommunications in the United States for the entire 20th century. It ran on the concept of this non-discrimination principle and this separation between the conduit and the content. And this continued even through the early years of the internet. The FCC's computer inquiries in the 1980s and 1990s were very clear about a separation between facilities on the one hand and content on the other, and in fact required at one point the telcos to have separate subsidiaries to run their transport operations as opposed to any information services they were into. So this continued until 2002, and then we have what I refer to as the FCC's original sin. This was led to us all being cast out of the garden. This was a decision. This was a decision where the FCC did away with this division between conduit and content, between carrier and payload, and determined that they were no longer separable. They were together formed an inseparable information service held together with the special DNS sauce. This decision went up to the U.S. Supreme Court in 2005 in the Brand X decision, and the Supreme Court did not approve the FCC's logic, but rather deferred to it. It's a doctrine called Chevron deference. One of the dissenters was Justice Scalia, interestingly enough, who said this is just too clever by half. The famous pizza analogy, clearly when you order a pizza, you can think about the pizza delivery separate from the pizza. So years of litigation, confusion, and wandering in the desert ensued. I myself was party to several Ninth Circuit cases involving companies that claimed that IP transport was something entirely different than what was contemplated in their interconnection agreements. So the FCC attempted a number of fixes, none of which worked. In 2005, they came up with 4 principles that consumers are entitled to access the lawful internet content of their choice. They're entitled to run applications and services of their choice. They're entitled to connect the devices of their choice, and they're entitled to competition among carriers, network providers, application and service providers, and content providers. Well, this didn't, it wasn't too long until Free Press brought a complaint based on a guy who liked barbershop quartets. And he used BitTorrent to share his barbershop quartets with his fellow aficionados. And discovered that for some reason the transmissions were interrupted. I think he discovered that the technical thing that was happening was a TCP reset function. Free Press brought the case to the FCC. The FCC called out a violation and required Comcast to change its ways. Comcast was the carrier in question. Comcast appealed. It went to the DC Circuit, and the DC Circuit rejected the 4 principles in a 2008 decision because the FCC really couldn't identify the authority on which it had propounded those 4 principles. I think the real problem was they were principles, they weren't rules. In any event, the FCC went back to the drawing board. In 2010, they came up with an order. This time they had rules: no blocking, no discrimination, transparency. But again, based on this concept that broadband internet access service was a information service and not a common carrier telecommunication service. So this case went finally back to the DC Circuit. Judge Tatel, a blind man who is just a phenomenal jurist. I mean, he ruled against the FCC twice, but in each case it was really well reasoned. And he ultimately wrote the decision, this decision in 2014, which agreed that content discrimination was a problem, approved the FCC's logic, and authority to do something about the problem, but rejected the FCC's broken model. You can't do this, the court said, if you call broadband access an information service. So your problem is what you did back in 2002. Essentially, you have to reclassify broadband as a telecommunications transport service. Well, the good news for the FCC was that the DC Circuit decision was really a roadmap to reclassification of broadband internet access service as a common carriage service. But still, the FCC didn't get it. In late 2014, they floated, or mid-2014, they floated proposals that were, again, based on this information service classification. It did not look good. Until 4 million people wrote into the FCC, 99% of which were in favor of reclassification as a common carriage, until John Oliver went on HBO with his famous rant, and until President Obama's strong, clear, and I think really knowledgeable statement about we need Title II. I listened to the guy. My own take was this: he gets it. He understands the technology. So the FCC reworked the rules. They reclassified broadband as a telecom service, and applied the rules to wireless as well as wireline. So what are these rules going forward? Well, you have your 3 bright line rules: no blocking, no throttling, no paid prioritization. You have a general conduct rule: no unreasonable interference or unreasonable disadvantage. And you have an enhanced enhanced transparency rule, which is essentially a consumer protection device. You must disclose what your networks are about. So on the no blocking of content, applications, or services, that's pretty straightforward. There were 2 exceptions: reasonable network management, we'll talk about that in a minute, and unlawful content. I know that's a whole other subject. I'm not going to get into that at all. The second rule was no throttling. This, again, is a bright line rule, not addressed to outright blocking, but conduct that inhibits the delivery of particular content, apps, or services, or particular classes of content, apps, or services. Again, 2 exceptions: the reasonable network management and the customer chosen speed tier. So if you choose a lower speed tier for a lower amount of money, that would you're essentially agreeing to that. It's customer driven. The FCC specifically mentions the problem of a carrier throttling the over-the-top content that competes with the carrier's own content. Throttling is the flip side of paid prioritization. So that's the third rule: no paid prioritization. Paid prioritization refers to the management of a broadband provider's network to directly or indirectly favor some traffic over other traffic by traffic shaping, resource reservation, and other methods, some of which are mentioned in the Open Internet Order. This is a bright line rule. You can't receive money or other consideration for prioritization, and you can't favor affiliated content. In other words, develop a business partnership and favor the content of your partner. Paid prioritization is a business decision, therefore reasonable network management does not apply here. It's just a bright line rule. You can't do it. So carriers cannot, for instance, prefer Netflix traffic over Amazon, or those 2 over a smaller competitor, say Fandor. So those are the 3 bright line rules. Now we have the unreasonable interference or unreasonable disadvantage standard. This is a general conduct rule. Carrier's conduct may not violate one of the 3 bright line rules, but a carrier's conduct may not violate one of the 3 bright line rules, but may still interfere with the consumers access to lawful content. That's really the key here. The consumer is in the center of this analysis. This rule governs conduct with edge providers, but on a case-by-case basis. As we'll see, the FCC shied away from really going deep on the peering and interconnection issues. Whenever reasonableness is involved, whenever a lawyer sees the word reasonableness, they know that there's a lot of guaranteed work out there for. It's a multi-factor test. The number of factors, I've highlighted the two most important ones, preserve end-user control and application agnostic. The FCC really focuses on those two, and I predict those two will be the center point and issue of any litigation that grows out of this. Other factors they look at: does this promote competition? Does it protect consumers? Does it promote innovation, free expression? And here's key for NANOG: is it consistent with network best practices and standards? The FCC defined what it was talking about here. It says standards adopted by open, broadly representative, and independent internet engineering, governance, and standard-setting organizations. So this is your opening. You will play an important part going forward in the development of these rules. I take this as a reference not only to NANOG, but to groups like ARIN and ICANN. The FCC specifically rejected a commercially reasonable standard. That was the standard they used in their roaming order when they tried to expand wireless roaming. They said this is a larger analysis. This is really not just between two carriers or what's reasonable between two carriers. This is about the public interest, and again, the consumer stands in the middle point of this analysis. Two specific questions that the FCC mentioned were sponsored data and data caps. And they say they are going to apply these rules to those two questions. My prediction is that sponsored data will have a very difficult time, but that data caps, particularly wireless data caps as we've seen, will pass muster. Okay, so now we get to the enhancements to the transparency rule. The transparency rule is not a new rule. They did not propound a new rule. This was the only rule that survived the DC Circuit appeal, and the reason it survived is because it's not a common carriage rule. It's really a consumer protection rule. So the old rule says, a person engaged in the provision of broadband internet access service shall disclose network management practices, performance characteristics, and the commercial terms, the full commercial terms of the engagement. This was directed at two constituencies, not just consumers. They talk about consumers having enough information to make informed choices. That's language you see in a lot of consumer protection statutes. It's in the California Public Utilities Code. But the second constituency was content, application, service, and device providers to help them develop, market, and maintain internet offerings. So you are within the protected class, if you will, of the transparency rule. The enhancements in the 2015 version of the Open Internet Order are price, full monthly service charge. So you can't give a price and then add on a lot of add-ons that are not fully disclosed in your advertising. Other fees, that's what I was just referring to, data caps and allowances, and performance characteristics such as speed, latency, and packet loss. In other consumer protection contexts, we've seen state and federal regulatory agencies come up with a matrix for such disclosures. For instance, the FTC's privacy matrix might be something the FCC will come to. All right, so what is reasonable network management? This applies to 3 of the 4 rules that we've talked about: no blocking, no throttling, and no unreasonable disadvantage or interference. Now, we have the typical bureaucratese definition here. A network management practice is reasonable if it is appropriate and tailored to achieving a legitimate network management purpose, taking into account the particular network architecture and technology of the broadband internet access service. Are you still awake? Really what it boils down to, and the FCC says this in one of the subsidiary paragraphs, is whether a practice is primarily motivated by technical network management considerations or business justification. If it's about business, if it's about revenue, you're going to have much tougher sledding. There's some bleed over here between the factors that we talked about, that I talked about a minute ago in regard to the no unreasonable interference or disadvantage standard. Does it allow for end user control? Is it application agnostic? So when the FCC announced this, they made a big deal of saying that this was not going to be standard utility style regulation. They were referring to a practice that's called forbearance. This is in the 1996 Telecom Act, and essentially allows the FCC to forbear, to not enforce rules in the 1996 Telecom Act when it finds that the public interest would not be harmed. So here, the FCC said it would forbear, that is, it would not enforce, rules relating to rate regulation, to tariffing, and to unbundling. I italicized unbundling because I think that really is an issue that the FCC, in all honesty, has just kicked down the road. They were not going to forbear. I'm very clear about not forbearing on rules relating to privacy, pole attachments, good news for Google and other who would come into the facilities world, on universal service, new proposals on universal service out a day or 2 ago from Chairman Wheeler, and disability access. So now coming to my own backyard, preemption of the states. Under the 1996 Act, it really changed the way regulation had been done. There was a strict divide up until that time about between intrastate carriage and interstate, and all kinds of separation rules, and it became very difficult to deal with. So the 1996 Act ushered in something that is referred to as cooperative federalism. The feds more or less set out the framework, and we color between the lines. There are two areas where the states have traditionally been very active. One is in consumer protection, billing issues, and the other is disputes between carriers. 2 California carriers are in a dispute. Even if it concerns interstate traffic, there's still 2 California carriers under the aegis or jurisdiction of the Public Utilities Commission. The Open Internet Order declares that broadband internet access service is, quote unquote, jurisdictionally interstate. But this doesn't mean, obviously, that it's factually interstate. What it does mean is that the states are bound by what the FCC says, and they're bound by the FCC's forbearance decisions. So what can the states do? The key word here is nothing inconsistent with what the feds have set out. So no new state universal service assessments. They were explicit about that. It's not a basis for requiring cable systems to get new telecommunications franchises. Still unclear how this is going to play out in interconnection disputes and billing. There's an interesting issue here because one of the things that the DC Circuit did in the 2014 Verizon versus FCC is rehabilitate Section 706 of the 96 Act, which delegated both to the FCC and to the states equally the role of promoting competition and removing barriers when it came to advanced telecommunication services, read broadband. So the states have a role in doing that, have an independent statutory authorization to do that, and the FCC's order acknowledges that, but doesn't really parse it out more finely. So what does this mean for you? A lot of talk about FCC takeover of the internet. I think that's misplaced discussion. For the last 20 years, we've had in the wireless area very light-handed regulation. There's been no rate regulation, virtually no entry regulation. It's all about terms and conditions and issues like roaming. So that certainly has not impeded the growth of the wireless industry, and I do not expect the open internet order to impede the growth of the broadband and internet related industries. If you work for an edge provider or competitive carrier, this might give you some tools to achieve more fairness and transparency in your interconnection with incumbent or other facilities-based carriers. There's no direct change in the interconnection rules. The FCC acknowledges a lot of conflicts that have been out there. The level 3 Netflix Comcast conflict, I was glad to see everybody behaving themselves this morning. It says that there are competing narratives about what happened. It says they're essentially going to wait and see. A rare act of regulatory humility, said we really don't understand this enough to make rules. So we're going to let you folks try to work it out and see what you come up with. If you work for an incumbent, you probably should take a look at your tariffs, contracts, rules, and policies to make sure they're transparent and fair, both vis-a-vis your end user subscribers and competing carriers and other commercial partners. So I think we've said enough on that. The larger picture, I'll close with this. I really think the Open Internet order is a watershed change in the way the FCC views the network. I'd say this is the end of the telephone network as we know it. This has been in the works for several years, National Broadband Plan and the 2011 Transformation Order, but this really hits it on the head. Dial tone is replaced by broadband connectivity. Voice is just an application. They specifically say that with regard to VoIP, and as we know, VoIP is pretty much going to be the voice product going forward. And they redefined the endpoints of the network. Previously, the NAMPA numbers had been seen as the endpoints of the public switch telephone network. Now the endpoints include IP addresses. Again, does this mean an FCC takeover of the internet? They explicitly address it on this count and say, no, this definitional change to our regulations in no way asserts commission jurisdiction over the assignment or management of IP addressing by the Internet Numbers Registry System, so I expect that the consensual decision-making of ICANN, ARIN, and others will go forward. So at the end of the day, I think what the FCC is saying here is that broadband is an essential service. It is, even if we don't regulate it completely as a utility, it is a utility. You cannot get a job now. You cannot find out about your community. You cannot do so many things if you are not on the internet. It's like water. It's like gas. And by the way, in gas regulation, over the last 20 years, there's been an unbundling that has occurred there. Gas pipeline operators are supposed to, I'm not a gas regulator, so I don't know for sure, but are supposed to be separate and apart from the gas generators. In the electricity field, another essential service, there's the whole issue now of net metering and feed-in tariffs. You have panels on your roof. On what terms and conditions are you going to be able to feed electricity back into the network? And I think broadband shares some of those characteristics. If broadband is going to be different than a traditional utility, what is going to happen is some sort of competition in the last mile. That's the key. That's the bottleneck. This can occur through unbundling regimes, something like the functional separation that Ofcom in the United Kingdom has pursued, or perhaps carrier-neutral municipally sponsored networks, or some combination of the three. But to the extent that you've got a monopoly there, you have a real need for, in my opinion, for some sort of neutrality or open internet rules. So, in closing, we need your help. The FCC needs your help. They're developing standards. I talked about the reasonableness criteria. I talked about best practices. You're on the front lines of that. We're trying to deal with known historical problems while honoring the uniqueness and wonder that IP technology has brought us. So with that, thanks for listening. I'll try to answer your questions. You can also email me questions at wit@cpuc.ca.gov. No questions? Good.
Tony. Question?
All right.
Yes. Hi, my name is Chris Woodfield. I'm with Twitter. Your mention of the fact that broadband is now being considered an essential service brings up some interesting implications. As we all know, telephone service was declared an essential service, and we had things like Universal Service Fund to make sure that rural areas had access to voice telephone service. Do you see a point where the current FCC standards for broadband would eventually become a baseline for some sort of universal service requirements? And you think that would be A, necessary or B, even desirable?
So we were taking bets on whether that question would come up, and the smart money was that it would. The FCC a day, 2 days, 3 days ago issued an order that goes down that road to redefining basic service to include broadband. I don't see any way around that. I think that talking about standalone voice, even if that's all you're using, that just does not make sense going forward as far as I can see. And I think the FCC says that between the lines by referring to VoIP as a data service rather than a transport service.
Thank you.
Jeff Houston, APNIC. Do you think that the regulatory system is suffering from lamppost bias? In other words, you're looking under the light of the lamppost because that's the easiest place to look. Whereas in actual fact, the intrinsic monopolies that are forming on the internet are in different places. You've got a long history of regulating carriage because carriage was central to telephony. In the internet, carriage is merely the sewerage, and that the value is in apps. And certainly it's true right now that apps are incredibly monopolistic. The DNS is largely serviced by a single provider. Even our email is serviced by only one or two. Is this a problem? And if it is a problem of these forming monopolies in applications and services, what do you see as your role as a regulator in looking at this upper level world that sits well above the traditional regulatory environment of carriage?
I think that's an excellent question.
Did you bet that was going to be asked as well?
No, but I've thought about that. That's definitely a question I've thought about. I've done some reading and research into search bias, all of the attendant privacy issues that the Europeans are so exercised about. There's no doubt that companies like Facebook and Google have tremendous market power. But I go back to a very simple principle. It's the wires, stupid. It really is. You talk about the protocol stack and lower level control. the people that own the wires are in a commanding position, from what I can see. These other market problems, I think, are more the province of the Federal Trade Commission. I think the PUC, the California PUC, and the Federal Communications Commission would do well to stick to the wires and to the market power that attaches to those wires and to the act of transportation of information.
So in effect, you're saying it's someone else's problem, but it's a problem.
Exactly. That is exactly. And I would, it's like the railroads. You've got one railroad track into town. The railroads themselves can be a problem there and extort super competitive rates from the people that they're serving. Or you can have a Rockefeller come in and co-opt the railroads. So that's the problem you're talking about.
Thank you.
Yes, Bill Goldstein. For reference purposes, I'm a retired product manager from AT&T and Managed Internet Services, though I'm here on my own, representing only myself. First question. Most large-scale exchange of traffic between networks is done via private peering. Given the transparency and bottleneck aspects of the current ruling, what do you think is the future of private peering? And the second question, of course, all this is under some very significant legal challenge. I just wonder what your observations would be on what you think the chances are of this latest ruling really standing the test of the courts going forward.
So let me take the second one first. I think the D.C. Circuit and Judge Tatel did the FCC and the United States a tremendous service in setting out a roadmap, and a logically coherent roadmap at that, to what the FCC should do. And the FCC finally followed that roadmap. So my money is on that this will be upheld in the courts. I'm not even sure if it will reach the Supreme Court, but and you will have, if it does reach the Supreme Court, you will have Judge Scalia, who's looking for a very simple, clear approach to regulation, and separating out the conduit in the way that the FCC has done, I think is clear enough for him. He's got his transport element as a separate element. As to private peering, Chairman Wheeler said in the last month or two that peering is just a fancy word for interconnection, a $25 word for interconnection. My guess is the FCC is going to stand back, gather data, and see if you folks can work it out among yourselves, and then only interfere or only regulate to the extent necessary to keep a level playing field. And again, with the consumer in the middle point. If data is effectively being, and information is effectively being made more difficult for consumers to reach, I think that's the point when the FCC will step in. I don't know if that answers your question, but.
Well, again, no one, it would be unfair of me to address you as to be, a substitute for all the courts and private rulings. I was basically interested in your observations as certainly very interested and very well-informed party to all this, and I appreciate the response.
Sure, thank you. I think.
Bill Manning representing the 70s.
All right.
And to answer Jeff Houston's question and a suggestion for the board, if he's interested in content control, invite the MPAA censorship board to come talk next time to talk about content control.
Even my sarcasm challenged mind gets the.
I just saying. I have a cognitive disconnect every time someone in the United States says broadband. I want to break out in laughter. Is there any expectation that when the FCC talks about broadband, or the Public Utilities Commission talks about broadband, or anyone else in the United States talks about broadband, they actually mean broadband instead of the FCC's current definition?
And what do you understand the FCC's current definition to be?
I'd have to go back and look at the stats, but when I check my Japanese friends, when they talk about broadband, they're talking about minimum 100 meg up, down, unfiltered, last mile. That, right? That's the old, you can get that out in, like rural Japan. The new stuff is a little faster than that. And so when I hear broadband in the United States, and I go talk to my provider in Los Angeles, and I say, I'd like broadband, and they say, we've got this deal for you. We can get you 1.5 megs up and down, and it's only going to cost you $135 a month. Such a deal. And I don't think that's broadband, and I don't think that's price competitive, and it makes me snicker. So can we get broadband, do you think broadband's going to change its definition?
Well, the FCC just redefined it upward to 25 megs down. That probably wouldn't satisfy you. But a lot of people are complaining that that's unrealistic and people don't need 25 megabytes and megabits. Thank you. I'm showing that I'm a policy guy, not a tech guy. There's pushback on what you suggest, but yes, there are people out there who say we have to go to a gigabit service, and I think we're moving in that direction. It might be slower than you'd like, but.
Hi, Patrick Elmer, Markley Cloud Services. Speaking specifically, actually about an answer you gave, not the presentation. By the way, the presentation was awesome, and kudos to you and the PC for finding you, so thank you very much.
Thank you.
Talking directly about interconnection, you mentioned during one of your answers that if the consumer is harmed, then interconnection might be there. I was worried, and this, I'm just asking for a little clarification, I was worried that the order would actually be as long as things are agnostic or even-handed across all comers, then it would be okay no matter what the rule was. But you're saying that the FCC will actually look at the consumer? And just to give a slight bit of context, for many years, for decades actually on the internet, it has been common for a carrier that either has or believes it has market power to specifically congest its inbound and outbound to the quote-unquote public, the core, the default free zone, whatever you want to call it, and force people to buy access if they want good connectivity to whatever is behind them. But that's even-handed. Everyone has to do the exact same thing. Is the FCC going to look at that and go, no, that's not correct? And then what are they going to do? Are they going to say, okay, here's a reasonable price, or you have to have settlement free to the ones above a certain size? Or, I mean, that seems like a hard problem to me to solve.
Well, that's a really interesting question, and I don't completely have an answer. My off-the-top answer would be to go back to the no unreasonable interference or disadvantage. And there, no unreasonable interference or disadvantage, not necessarily vis-a-vis other providers or competing carriers or content providers, but vis-a-vis what is possible. That strikes me as a unfair business practice in and of itself, what you describe. And I'd actually like to know more about that. And Susan Crawford also talks about that, artificially constrained bandwidth, forcing consumers to, or allowing the company to upsell consumers. So if you could contact me afterward, I'd like to know more about that. I think there are tools there to deal with that. I'm not 100% sure what they are, as I stand.
I'd be happy to talk to you. So I don't know, I'm sure hundreds of people in this room, but you'll get a lot of email in the very near future.
Okay, please. I appreciate it.
Randy Bush, IIJ. I think the second half of Bill's point was price, right? As to how much bandwidth is good enough, you know, if God had meant us to fly in airplanes, she wouldn't have given us trains. I have 3 home internet connections. One is Comcast, for which I pay $70 a month and get about 20 meg down. And thank you, John, if you're here, I get IPv6, which I can't even get in this room. Don't turn off V4. You can't get it. Can't get DNS over V6. The other is Time Warner. I pay $103 a month for 15 meg down and 1.5 up. And the third is NTT. I pay $30 a month for 100 symmetric. And it's going to go to $40 a month when I go to gigabit, and they're apologetic. And that's what Bill means by what we say here is broadband is BS.
Thank you. So to move this issue in the policy world, I would ask you to send me the data on that because it's very helpful and something I'm interested in. But to move the issue in the policy world, you need studies, you need comparisons. The Berkman Institute at Harvard did a study about 3 or 4 years ago finding that in Europe you could get much more speed for many fewer dollars. And that study instantly became the target of attacks that, to their credit, they really didn't pull back from their conclusions, although they softened them some. And there are other people out, I won't mention any names, making on the circuit saying that European, US comparisons show that we're doing just fine and the market is working just fine. So we do need good comparisons, and my own thumbnail comparison, I have a friend in Hamburg who gets for 27 euros voice and 10 to 15 megabits, whatever. I mean, compare what you would pay for that in the United States. Similarly, have an acquaintance in London who even less than that. So I think we need good cross-country comparisons to drive that discussion.
Hi, I'm Anish Advani. I'm representing the University of Colorado Boulder in the college immersion program. So I'm primarily a tech student trying to understand the intricacies of policy, so forgive me if my question sounds stupid. Is the FCC the only body that regulates the rulings of paid prioritization and non-discrimination? If yes, then do you think the FCC is equipped with enough resources to detect and regulate any infringements or indiscretions that might occur?
You asked 2 very good questions. One, the Federal Trade Commission has some jurisdiction in this area, but they do not, due to a long outdated law, have jurisdiction over common carriers, and that needs to change. Commissioner Wheeler is, I think, dedicated to working with the Federal Trade Commission and bringing their expertise on board. Very good question. And as to your second question, whether the FCC has sufficient resources, I think my answer, from what I can gather on the West Coast here, is no, they don't. They have one administrative law judge. If they are really going to elaborate through a series on a case-by-case basis, which is what they say, they're going to need more administrative law judges, more capacity to do dispute resolution than they currently have. Does that answer your question?
Yes, it does. Thank you.
Time? Thank you very much.
Yeah. Thanks very much, Chris.